with its laws, its processes, and its procedures, the existence of the courts-martial cannot be questioned. Let me conclude on this note. Courts-martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the Army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system, and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature, and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the courts-martial of the cross-appellant stroke respondent and civilians of equivalence under section 1191G, read 1171G, is in breach of articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts-martial be suspended forthwith. An injunction doth issue restraining the instigation, reopening, or continuance of the respondent's trial before the general court-martial or other courts-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings of movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant Ogwang Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts-martial. In this regard, an amendment of the Uganda People's Defence Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts-martial. The other question Ogwang raises is a requirement to delimit what a service offence is during peacetime. I propose that a soldier who commits a civilian offence when he is off post and away without pass leave or a wall should be arraigned before the civil courts, civil as opposed to military courts. The cross appeal succeeds. The main appeal succeeds in part. I make no order as to costs.
I call upon Lady Justice Elizabeth Musoka to deliver her judgment. You will please bear with her. I think she's got a little cold, so she needs your patience and understanding, my lord.
I hope you hear me. My voice is a bit coarse, but this is a summary of my judgment. The judgment will be provided as the leader of this panel, the head of the panel, will advise. The appeal and cross appeal in this case, again, is the decision dated 1st July 2021, rendered by the Constitutional Court. The quorum of Kakuru, Obura, Madrama, Musota, and Kasule acting judges of the Constitutional Court. That is Michael Kabaziguruka, Honorable, versus Attorney General. The Attorney General is the appellant, stroke cross respondent, and Honorable Kabaziguruka is the respondent cross appellant, stroke cross appellant. The particulars relating to the declarations and orders sought in the respondent's petition, the issues identified for determination by the Constitutional Court and its decision on those issues, as well as grounds of appeal and those of the cross appeal, have been set out in detail in the judgment of the Honorable the Chief Justice, which I've had the opportunity to read in draft. I also had the opportunity to read the draft the judgment of the judgment of Mugenyi, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into a discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act of 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now Cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable the Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised Act should apply. My judgment, and I said I'm giving a brief summary of it. As I have indicated in my judgment, which you'll get, the grounds of appeal and cross-appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court Martial and the other military courts, and if so, what is the scope of those limits? Whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court Martial is a subordinate court within the meaning of Article 129(1)(d). Whether the General Court Martial had jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's right to a fair trial. Whether the General Court Martial and other military courts lack the capacity to render a fair trial under Articles 28(1) and 44C. And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament may confer on any military court to only matters falling within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offenses committed by members of the UPDF, and the nature of punishment that can be imposed for such offenses is limited to the disciplinary sanctions which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which conferred jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offenses under Part 6 of the UPDF Act. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, insofar as the punishments prescribed for Part 6 offenses are not only limited to discipline sanctions, the only punishments that can be imposed by military courts under 2010, but include serious punishments like the imprisonment and the death sentence. Second, in respect of Section 2 of and Section 179, which confers jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offences under the Penal Code Act and other enactments. The jurisdiction also goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that punishments prescribed under the relevant laws are not limited to only disciplinary sanctions. The only punishments that can be imposed by the military courts under Article 2010. But they include serious punishments like imprisonment and death sentence, as I said. Thirdly, in relation to Section 2 and Section 1191G, which confer jurisdiction on the General Court Martial and other military courts to try non-members of the UPDF who are alleged to have aided and abetted members of the UPDF in commission of Part 6 offences. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that the category of persons covered by this jurisdiction are not members of the UPDF, in respect of whom Article 210B was intended to cover. In addition, as with the first two categories, the jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF because the prescribed punishments for Part 6 offences, which include the imprisonment and death, are more severe than the disciplinary sanctions which can be meted by the military courts under Article 2010B. Fourthly, with respect to Section 1191H, which grants jurisdiction to the General Court Martial and other military courts to try non-members of the UPDF who are found in possession of proscribed military equipment, this jurisdiction also goes beyond the sphere of discipline and removal of the UPDF, members of the UPDF, for three reasons. First, the persons affected are not members of the UPDF who fall within the jurisdiction of the military courts. Secondly, Section 1191H appears to be a penal provision, but it does not prescribe a punishment. And thirdly, the punishment for analogous offences under other laws include terms of imprisonment, which fall outside the nature of punishments that can be imposed by the military courts under Article 210B. Which are limited to disciplinary sanctions. In light of these observations, I find that therefore, to the extent explained, unconstitutional and null and void. For the fourth category, which is provided for under Section 1191H of the UPDF Act, I find that it does not fall under the sphere of discipline of the UPDF, as it is neither concerned with members of the UPDF nor with disciplinary sanctions that can be given to members of the UPDF for engaging in unacceptable conduct. For analysis, the analysis of the above second question will be found on page 10 to 15 of my judgment. The third question, it's with respect to the question of whether the General Court Martial is a subordinate court. I note that Parliament is required to enact legislation under Article 129(1)(d) for the creation of a subordinate court. But for the General Court Martial, Parliament moved under Article 210B with an intention to create a disciplinary body for the UPDF, not a subordinate court. I also find that in any case, going by the provisions of Article 210B, the framers intended that military courts could only be established as disciplinary organs of the UPDF and could not be vested with a general judicial function so as to leave room for their establishment as subordinate courts. In addition, I find that a court can only qualify to be called a subordinate court if it's subject to the supervision of a superior court through revision proceedings. And note that the General Court Martial is not subject to the supervision of any of the superior courts under Article 129(1), including the High Court, Court of Appeal, or Supreme Court. And I conclude that on this account alone, cannot be stated that the General Court, in my view, that the General Court Martial is a subordinate court. I also find that it's not a subordinate court because it lacks essential features found in other courts of judicature, such as competence of its officers as legal professionals and lack of independence and impartiality. With all due respect, I propose the overruling of the dictum of Mulenga JSC in this court's decisions in Attorney General versus Joseph Tumshabe and Attorney General versus Uganda Law Society. Citations are given, in which Mulenga JSC expressed the view that the General Court Martial is a subordinate court within the meaning of Article 129D. Because in my view, that dictum was erroneous. I also point out that the Joseph Tumshabe case was concerned with the version of the GCM of the General Court Martial under the now repealed UPDF Statute number 3 of 1992, enacted before the coming into force of the 1995 Constitution, which makes it distinguishable since this appeal is concerned with the version created under the UPDF Act 2005. I therefore find that in the present case, this court does not have the same liberty to characterize the General Court Martial, since when Parliament enacted the UPDF Act, which provides for the current version of the General Court Martial, it could only establish a disciplinary body for the UPDF under Article 2010A and B. The third question, the analysis of the third question will be found on pages 15 to 19 of my judgment. Now the fourth question, regarding the constitutionality of the respondent's arraignment. I note that in light of the position taken in my judgment, that under Article 2010B of the 1995 Constitution, the General Court Martial is limited to hearing cases involving members of the UPDF. And I take the view that since the respondent was not a member of the UPDF at the relevant time, his arraignment was unconstitutional. For the analysis on the fourth question, see page 17 of my judgment. Fifth question, in relation to the fifth question, whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44C, I express the view, in agreement with the views expressed in the respective judgments of the Honorable the Chief Justice and Mugenyi, Justice of the Supreme Court, that there exists several deficiencies the setup and operations of the General Court Martial that diminish its capacity to properly adjudicate cases. And these include objective lack of independence of both the General Court Martial as a court and of its members as individuals. The lack of competence of the members due to their lack of legal training and knowledge, and the absence of effective mechanisms for reviewing the correctness of the decisions of the GCM, of the General Court Martial. I note that our constitution was put in place to ensure a just, free, and democratic nation which encourages respect for people's fundamental rights, which was the reason for establishing the courts of judicature under Chapter 8 and vesting them with the mandate to exercise judicial functions fairly and do justice in all cases. I note that for criminal trials, the needs of justice require that accused persons are tried before competent courts or bodies that are capable of guaranteeing the right to a fair trial, and that, unfortunately, the deficiencies highlighted above render it impossible for an objective observer to conclude that the General Court Martial can guarantee the right to a fair trial. And as it is well known, a fair trial is a vital prerequisite for ensuring justice in criminal cases. I therefore find myself in complete agreement with the analysis and views of the Honorable Chief Justice and Genyi JSC on the deficiencies in the General Court Martial and how they render it incapable to accord a fair trial to the people that fall within its jurisdiction. In light of the highlighted deficiencies, I express the view that it is necessary not only to give a strained construction of the matters that properly fall within the ambits of discipline and removal of members of the UPDF, but also to ensure that as far as possible, offences are tried by courts of judicature, not military courts. I further express the view that it is, therefore, inappropriate to grant the military courts jurisdiction beyond the trial of members of the UPDF for disciplinary offences under Part 6 and the imposition of disciplinary sanctions as punishment for those guilty of disciplinary offences. All other criminal matters ought to be handled by courts of judicature. However, even in cases involving disciplinary offences under Part 6, there should be established a mechanism providing for revision of the decisions of military courts by the courts of judicature to ensure that the ends of justice are met. In my judgment, I exhort the learned Attorney General to take interest in the best practices set out in the respective judgments of the Honorable the Chief Justice and Mugenyi JSC, which represent the best reforms to improve the military court system. These are found on pages 19 to 20 of my judgment. In conclusion, and for the reasons given in my judgment, which you'll get, I would disallow all grounds of appeal and allow the sole ground of cross appeal. I would make I'll take on the declarations numbers 4, 5, 6, 7, and 9, and orders 1, 2, 3, 4, 5, and 7 contained in the judgment of the Honorable the Chief Justice, since they are consistent with the findings in my judgment. I would also commend the Honorable Chief Justice's advisory orders to the attention of the learned Attorney General. I would then make the following separate declarations arising from the findings in this judgment, in addition to the ones I have pointed out above contained in the judgment of the Honorable the Chief Justice. Number one, General Court Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court Martial and other military courts are disciplinary organs of the UPDF established under Article 210, whose jurisdiction is limited by Article 210b to handling matters related to discipline and removal of members of UPDF, including former and assimilated members of the UPDF, as stipulated under Section 1191A to F of the Act. Number three, the jurisdiction of the General Court Martial and other military courts is under 210B, limited to hearing matters involving disciplinary offences under Part 6 of the UPDF Act, committed by members of the UPDF as defined in paragraph B, and is also limited to the imposition of disciplinary sanctions to the members of the UPDF found guilty, as I have already stated. I enumerated the offense, the punishments earlier on. Jurisdiction of the General Court Martial and other military courts does not extend to hearing cases involving civilians who are neither former or assimilated members of the UPDF, as defined in paragraph B. The hearing of cases involving civilian non-members of the UPDF falls within the jurisdiction of courts of judicature established under Chapter 8 of the 1995. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of offences under Part 6 of the Act, and where it is appropriate to impose a sentence of imprisonment or a more serious sentence, falls within the jurisdiction of courts of judicature established under Chapter 8. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of general civilian offences created under any enactment other than Part 6 of the UPDF Act, falls within the jurisdiction of the courts of judicature established under Chapter 8, the Constitution. Section 2, 1191H and G, and Section 179 of the UPDF Act, in as far as they confer jurisdiction on the court martial and other military courts to the constitutional limits, contrary to the constitutional limits described above in this judgment, are unconstitutional and null and void. I would make the following orders, in addition to the ones which I adopt from the Honorable the Chief Justice, which are in his judgment orders, in the draft judgment which I read. There were orders 1, 2, 3, 4, 5, and 7. I would just add that going forward, only cases involving members of the UPDF and related to disciplinary offences under Part 4 of the UPDF Act should be tried by the General Court Martial and other military courts, and that only the disciplinary sanctions as described at C above can be imposed by the military courts in those cases. Number 2, where a military court determines that the imposition of a more serious punishment, such as imprisonment or the death sentence, is necessary, in addition to removal from service, the military court shall forward the case filed to the Director of Public Prosecutions with a recommendation for institution of criminal proceedings in a competent court of judicature. I'll adopt the order made by the Chief Justice on the respective effect of, or otherwise, of this judgment. Otherwise, I would award costs of the appeal and the cross appeal in this court and the costs in the Constitutional Court to the respondent.
Now we will now have Honorable Justice Mike Chibita deliver his judgment.
Thank you, Honorable Chief Justice, my lords, ladies and gentlemen. I've read the lead judgment of Winyidolo Chief Justice in draft. On the whole, I agree with the spirit, findings, declarations, recommendations, and orders. Before delving into the substance of the judgment, let me deal with one preliminary point of public interest. As one of the surviving members of the original panel that first heard this matter, I reiterate the explanation that unprecedented occurrences indeed hindered and stood in the way of the expeditious disposal of this appeal. The retirement of Honorable Justice Ezekiel Mhanguzi and the deaths of Honorable Justices Opio Aweri and Stella Rach Amoko, all of whom were members of the original panel, ensured that reconstitution of the panel was inevitable. It was not until Honorable Justices Catherine Bamugemereire and Monica Mugenyi, Justices of the Supreme Court, were appointed in 2024 that a full panel could finally be reconstituted. Suffice to say that any delay in dispensing justice is always regrettable, whatever the cause. The larger principles at play in this case are the age-old principles of the jurisprudence of criminal law. It is universally accepted in the common law system to which Uganda subscribes that the presumption of innocence is a bedrock of our criminal law. And this has been incorporated in the 1995 Constitution of the Republic of Uganda under Article 28(3)(a), which states that every person who is charged with a criminal offense shall be presumed to be innocent until proved guilty or until that person has pleaded guilty. In other words, everybody is presumed innocent until proven guilty by a competent court. What we are investigating in this case is whether the court-martial is a competent court to try civilians or anybody else brought before it for that matter. Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution, which reads, in the determination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law, close quotation. So the question is, does the General Court-Martial guarantee these fundamental freedoms? The answer, as far as civilians are concerned, has been found to be largely in the negative. In accordance with the doctrine of precedent and in view of an earlier holding by this court, the conclusion in Attorney General versus Joseph Tumushabe that the General Court-Martial is indeed a subordinate court as contemplated under Article 129(1)(d) of the Constitution is still good law. Secondly, that Section 117(1)(g) of the UPDF Act does constitute exceptional circumstances under which the trial of civilians in military courts would be justified, and to that extent is not inconsistent with Articles 28(1) and 44(c) of the Constitution. However, I agree that Section 117(1)(h) of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution. On the issue of remedies regarding matters pending before the General Court-Martial involving civilians, I would agree that they will be remitted to the civilian courts for consideration. And in regard to trial of members of the military, I agree with the recommendations given to the executive and parliament to work on the necessary amendments in order to bring the court-martial in conformity with the Constitution. I'm persuaded by the doctrine of prospective annulment as opposed to retrospective annulment, as laid down in the case of Calista Andrew Mwatela and two others against the East African community, which was applied in the case of Bob Kasango against Attorney General. The same principle was held in the case of East African Law Society and four others against Attorney General of Kenya and three others. The court declined to invalidate amendments found to violate the treaty. Court, however, invoked prospective annulment and declared that involvement of the people in the treaty amendment process would have prospective application. In the case of A against the governor of Abba Hill Prison, the Supreme Court of Ireland held that the declaration of unconstitutionality of a law has prospective effect only. It was further held that the court cannot interfere with final decisions of the courts, even if based on a law later to be found unconstitutional. Otherwise, retrospective annulment or retrospective effect, as termed elsewhere, would create an absurdity which the courts can and should never intend. Dated at Kampala, the 31st day of January, 2025.
Now we can ask Lady Justice Twaise to deliver her judgment.
Thank you, my Lord. Thank you, my Lord Chief Justice. I will proceed to read my judgment as follows. I have had the benefit of reading in draft the lead judgment by Alphonse C. Owindolo, Chief Justice. I agree with the analysis, decisions, conclusions, and orders that are proposed in his lead judgment. The background to this appeal and the respective cases for the parties to the suit have been ably articulated in the lead judgment and in other judgments prepared by Myland sisters and brothers in this appeal, which I have also had the benefit of reading in draft. It is therefore not necessary to reproduce the same. I will only add my opinion regarding the issue relating to the capacity of the I will only add my opinion regarding the issue relating to the capacity of the General Court Martial to render a fair trial as envisaged in Article 28(1) of the Constitution of Uganda. The jurisdiction and competence of the said court is challenged by the respondent in this appeal. The appellant, on the other hand, contends that it is a court of competent jurisdiction provided for under Article 210 of the Constitution of Uganda and Section 197, now 195 in the revised edition, the year 2023 of the Uganda People's Defense Forces Act. The appellant also, in opposition to the respondent's assertions, contends that the establishment of the General Court Martial does not contravene Articles 28(1), 126(1), 129(1), 210 and 267, 1D of the Constitution of Uganda. The General Court Martial is created under Section 197, now Section 195 in the revised version of the laws of Uganda, of the Uganda People's Defense Forces Act. Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offenses created by the UPDF Act, committed by members of the military forces and persons who aid or abet such offenses. In short, to administer military justice in Uganda with jurisdiction to handle offenses specified in the Act, mainly for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadiz courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament. To the Supreme Court, the Court of Appeal, and the High Court shall be superior courts of record, and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an Act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial, set out under Section 195 in the revised version of the laws of Uganda 2023 of the UPDF Act, is that they should essentially be army officers, with the chairperson not being below the rank of a Lieutenant General. Save for the chairperson of the court, of the Court Martial Appeal Court, who is required to be an advocate, qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications. It is to be noted that both the General Court Martial and the courts of judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as the death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The criminal prosecutions conducted before such courts should ideally be controlled by the Director of Public Prosecutions. This would be a safeguard for a fair trial envisaged under Article 28(3) of the Constitution of Uganda. In addition to the International Covenant on Civil and Political Rights, to which Uganda is signatory, and all other international human rights instruments, binding or persuasive, which have been ably highlighted in the other judgments to this appeal. In my considered opinion, it would not matter whether in actual fact, that is de facto, the members appointed to sit on the General Court Martial, in the wisdom of the appointing authorities, do possess the legal qualifications to be competent to adjudicate criminal matters, especially those attracting heavy penalties. As long as the UPDF Act that creates the General Court Martial does not expressly include legal qualifications as a requirement for appointment to the General Court Martial, that is de jure, the competence and capacity of that court to handle criminal trials would still be questioned as is being done in this appeal. This is based on the cardinal principle in our legal system that justice must not only be done, it must be seen to be done. The General Court Martial would only be competent to adjudicate over criminal matters of not only civilians but also military persons if it were a court of law with the requisite structures to conduct a fair hearing as envisaged under Article 28 of the Constitution of Uganda. There can be no fair trial as envisaged in Article 28(1) of the Constitution in an incompetent court. It is in that regard I would, with respect, not agree with the appellant's contentions that the General Court Martial is a court of competent jurisdiction to hear criminal matters. In its present state, the General Court Martial, though lawfully set up by an Act of Parliament deriving such powers from Article 129(1)(d) of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces. The result, based on the above, and in addition to the reasons, decisions, conclusions, and recommendations for legal reforms stated in the lead judgment, which I associate myself with, I would conclude that this appeal fails, save for the issue regarding the establishment of the General Court Martial as a court of law. I would dismiss it to that extent and allow the cross appeal. I would award the course of this appeal to the respondent in this court and in the courts below.
Thank you, my lord. I propose we take a 10 minutes health break.
Yes, my lord.
Yes, because 200 pages will take us up to midnight, I think. So, okay. So 10 minutes break.